For some reason, I thought I wasn't speaking until another couple of hours, but I think I've got the my timings wrong between between now and then. But I am prepared. So thank you very much for the invitation. Forgive me if I mainly read my text, but that'll keep me to time, I hope, and maybe also some time for one or two questions. There are estimated to be 2.3 billion Christians worldwide, of whom over half are Catholic. Abortion is not mentioned in the New Testament, but it is mentioned in the Didache, a document of the second generation of Christian believers, typically dated from the 1st century of the Common Era, and it's mentioned frequently by Christian theologians from that time. So Christian reflection on abortion covers almost 2,000 years and more than 1 billion people. So it's quite a big topic from that point of view. I have written a book which charts the development of Christian belief in this area, which is called The Soul of the Embryo, but I couldn't possibly do justice to it in 15 minutes. So I propose to look more specifically at the Supreme Court's judgments, Roe v. Wade and Dobbs v. Jackson, from a Catholic perspective, and also particularly from the perspective of Catholicism within the United States of America. Abortion was unlawful in English common law and was a criminal offence, at least after quickening, but it was only in the 19th century that statute law, laws passed by parliaments or states, prohibited abortion at all stages, both in England and in the United States. These laws, the passing of these laws in the 19th century had very little to do, if anything, to do with religious influence. Certainly it was not due to Catholic influence, which was very marginal in the United States and was legally suppressed in England at the time. The statutory prohibition on abortion was rather due to the influence of doctors and concerns in relation to public health in particular. And the overturning of these restrictive statutes by Roe v. Wade also had very little to do with religion. However, the reaction against Roe v. Wade and a sustained campaign for maybe 50 years, almost 50 years, against Roe v. Wade and a wish to overturn it, certainly did have a religious influence, especially an alliance of conservative evangelical Protestants in the United States, who comprise about 1/3 of the United States population, and the Catholic Church, which comprises between 1/5 and 1/4 of the US population. So an alliance between evangelicals and Catholics over a period of 50 years certainly was very prominent politically in the overturning of this judgment. It is surely significant that whereas only one of the 9 justices who decided Roe v. Wade was a Catholic, Brennan, who in fact voted with the majority, whereas 7 of the 9 who decided Dobbs v. Jackson were raised as Catholic. 7 out of the 9 Supreme Court justices. One, though he practices as an Anglican, was in fact raised as a Catholic, Neil Gorsuch. Went to Catholic school, and his doctorate from Oxford University was under a very renowned Catholic philosopher, John Finnis. So intellectually, he's perhaps one of the most Catholic of the Supreme Court justices. The remaining 2 Supreme Court justices are not Protestant, but Jewish, Breyer and Kagan. And it's noteworthy that all the presidents who appointed these were Protestants of some kind or another. None of them was Catholic, none of them was Jewish. But Republicans mostly appointed Catholic judges, and Democrats mostly appointed Jewish judges. This was more evident when Ruth Bader Ginsburg was still on the court, and there were 6 Catholics and 6 Catholic judges and 3 Jewish judges. 5 of the 6 of the Catholics were appointed by Republicans, and all 3 of the Jewish judges were appointed by Democrats. And I would suggest that, at least in relation to Catholicism, which is what I can speak about, this pattern of political and religious alignment was due to a mixture of influences and as much national and political influence on religion as it was religion's influence on politics. It should be acknowledged, of course, that there are many Americans who identify as Catholics who are in favour of very permissive abortion laws, and this would include the current President of the United States, Joe Biden, the Speaker of Congress, Nancy Pelosi, and one of the Supreme Court Justices, Justice Sonia Sotomayor. And the Catholic vote is roughly evenly split between Catholics, between Republicans and Democrats. They tend, on average, more to vote with the winning president, though not always. Nevertheless, the Catholic Church is strongly associated with the pro-life movement, and this is particularly true of the bishops and of a succession of recent popes, perhaps most notably Pope John Paul II. The common opinion of Catholic theologians is that the life of a human being begins at conception, so that the fetus is a human being in the full sense, and the state has a clear duty to do what it can, reasonably, to prevent elective abortion. And I abstract from the rare cases of emergency obstetrics and what's called therapeutic or indirect abortion. It is true that the law doesn't prohibit all wrongful actions, and Thomas Aquinas, who's perhaps one of the most important thinkers in the Catholic moral tradition, was clear that the law should not prohibit an act if the law was likely to be ineffective and counterproductive, or if it was disproportionate to the wrong it was seeking to address. On the other hand, as Pope John Paul II made clear, protecting the lives of innocent civilians is the first duty of the state, and the most basic reason for the state to restrict liberty. So from the perspective of mainstream Catholic thought, Roe v. Wade was an unjust decision because it prevented the states from protecting the unborn child. In Roe v. Wade, the decision of the judges was appealed to very broad principles of privacy and of liberty, which they argued were implied by the United States Constitution, a penumbra of rights it was sometimes called. And thus state restrictions on abortion were deemed to be unconstitutional. This leads to two possible objections to Roe v. Wade. The first kind of objection is that there is nothing actually explicit in the Constitution about abortion, one way or another. So it's very odd to say that laws against abortion are contrary to the Constitution. More subtly, it could be argued that the further we move away from the original language of the text, the stronger the need to show clear precedent and the greater the need for humility on the part of judges rather than judges legislating from the bench. This objection to Roe v. Wade embodies what's sometimes called an originalist approach to the text of the US Constitution. The usefulness of this approach encouraged many Catholics in America to take an originalist view of the Constitution. But it should be noted that there's very little in the Catholic tradition itself about constitutionality and originalism. Alternatively, someone could argue that there are rights which are implied by the Constitution which were not appreciated by the Founding Fathers and are so not explicit, but at the same time deny that access to abortion is such a right. Someone might argue that the judges in Roe v. Wade were mistaken, not because they appealed to a broad range of rights and principles, but because they failed to give weight to other rights and principles, and especially the right to life, which is the most fundamental of rights. What is striking about the Dobbs v. Jackson judgment, which, as I say, the majority of the judges were actually practicing Catholics, is that the arguments are primarily originalist. The majority criticised Roe v. Wade as an exercise in judicial power. However, as the dissenting judges pointed out, if the main problem with Roe is departing from the text of the Constitution, then the issue is not particular to abortion at all, and it might affect other decisions which have been made by the Supreme Court. Indeed, Justice Clarence Thomas embraces this conclusion in his concurrence and suggests that there may be other decisions which the court should revisit. On the other hand, Justice Brett Kavanaugh argued that the decision in Dobbs v. Jackson was about abortion and only about abortion and didn't give precedent for decisions other than abortion. It was different from sexual relations or contraception or marriage precisely because of the presence of the life of the unborn child. It is because of the presence of this unborn life that there's no valid precedent for Roe v. Wade, that Roe v. Wade was unprecedented. Here, Kavanagh is closer to the traditional Catholic concern about abortion than Clarence Thomas is. The primary problem from a Catholic perspective with Roe v. Wade was not how far it departed from the text of the Constitution, but how far it departed from natural justice, as natural justice was understood within the Catholic tradition. Roe v. Wade was unjust because it prevented states from acting on their recognition that the unborn child is a natural person with an inherent right to life.